We go to bond court in Miami, Florida. The defendant is 23-year-old Deontay Blackman. He's facing a number of charges, including attempted sexual battery, armed burglary, and assault with a deadly weapon. Blackman allegedly followed a woman into the elevator of her upscale condominium. As seen on this surveillance video, he appears to be on the phone while the woman stands just a few feet away. Blackman then followed the woman to her apartment and allegedly forced his way inside. He then allegedly struck the woman with a metal pipe before demanding oral sex. She resisted, and after several minutes, escaped to the bedroom and screamed for help from the balcony. Blackman took off and left the building using the same entrance from which he arrived. He was arrested 2 days later and now appears before Judge Alberto Millian, hoping to be released on bond.
Mr. Blackman, good afternoon.
Good afternoon.
How are you doing today?
I'm doing good. I'm ready to get this over with. Tell my side of the story.
Yeah, that may not be possible. You're being charged with threats of attempted sexual battery. It's punishable by up to 15 years in prison. Armed burglary with an assault or battery. That's punishable by life in prison.
The judge gives the public defender who's representing Blackman a chance to speak.
Sir, I'm gonna advise you not to talk about the facts of your case today.
Mr. Rucker, do you have any argument?
As far as the on the four corners of the
Yes.
Mr. Blackman, please don't talk while your attorney's speaking.
When the public defender's finished speaking, the judge goes over the defendant's bond.
Says the count number one, I'm going to set the bond at $7,500. As to count two, it's going to be no bond. As to count four, it's going to be $5,000. And as to count five, they'll be held without a bond. All right, good luck to you, and somebody from the public defender's office will be in touch with you in the future.
Okay, so I don't have a bond.
In 2 counts, I think 3 counts, you don't have a bond, and I'm also signing a stay-away order from the alleged victim. You're to have no contact with that person, direct or indirect. Understood?
Understood.
But Blackman refuses to go quietly.
My thing is, I don't have a chance to explain my side of the story, what really happened, or because
I advise you that right now is not the time for that.
Sir, I think your attorney's trying to tell you not to speak about the facts of the case. Everything you're saying here is being recorded and can be used against you in a court of law.
It's pretty good advice, although Blackman doesn't take it.
Okay, I understand, but I'm just telling my side of the story because what's on paper is not.
I'd advise you not to talk about the facts of the case. Okay?
Okay.
Good luck to you, sir.
Blackman's pled not guilty, and his trial is pending. Next, we go to a virtual hearing in Tampa, Florida. The defendant is 33-year-old B.J. Dreggers. He's been charged with fraud and petty theft for trying to pass bad checks. Today, he appears remotely before Judge Michael Williams to enter a plea. The state initially offered a deal where Dreggers would plead guilty and get sentenced to 18 months probation. If he decides to go to trial and is convicted, the former Marine could be looking at 5 years behind bars.
B.J. Dreggers.
Yes, sir. Good morning, Your Honor.
Yeah, good morning. Last time we were in court, he was shooting up drugs on my Zoom.
That's right. 3 months earlier, while waiting for his preliminary hearing to begin, Dreggers engaged in some illegal drug use. Judge Williams didn't watch it live, but a prosecutor did and shared it with the court. And the judge isn't happy about it.
Yes, sir. I apologize to yourself and the court for that, sir.
I only go so far, but
Yes, sir.
it's bad enough I got to put up with people smoking cigarettes and everything else. I don't need that.
No, sir.
I don't know. What's your resolution on him?
Dreggers' attorney David Hall steps in to do some damage control.
In my conversations with him, he's been entirely professional, respectful, remorseful about his actions.
I instructed him to appear in person on 6/4/21, and he didn't. And then he shows back up on Zoom on June 15th, and that's when he's shooting up on the Zoom.
Despite the judge's remarks, Hall requests the court stick with the original deal of probation. But for Judge Williams, it's not that simple.
18 months of probation. He wants to resolve it to the court. I'll do it today for 180 days plus 18 months. I'm not taking probation today and he gets out. I think I'm usually pretty relaxed on certain things, but you know, you shoot up on my Zoom, that's different.
Mr. Dreggers, the court is rejecting the plea agreement with the state, proposing 180 days in custody followed by 18 months probation. Is that something you want to do? The alternative would be to set it for trial.
Dreggers doesn't love either of the choices, so he makes his own request.
Is there a way to have stricter probation or something of those guidelines?
No.
Dreggers is given a month to discuss things with his attorney on how he wants to plead.
All right, Mr. Dreggers, come on up.
Once again, he appears before Judge Williams, who, after doing some of his own reflecting, has a new outlook on the case.
Mr. Dreggers, I've been thinking about your case. You're a veteran, correct?
Yes, sir, I am.
What branch?
Marine Corps.
All right. There's a once-a-year docket that I do, and it's called the Veterans Outreach Court. So
Yes, sir.
What I'm proposing is we set you on that Veterans Outreach Court docket.
Thank you, Your Honor.
Dreggers appeared on the veterans docket, and the judge gave him a second chance. He's released and given 18 months probation, plus mandatory drug and alcohol testing.
Just work on getting clean and moving forward. Let's have a good ending to a bad situation, okay?
Hey, Judge, I appreciate everything you've done for me, sir.
You get clean, I'm happy.
Dreggers is currently employed and taking steps to remain drug-free. We head to Tampa, Florida for the trial of 45-year-old Trevor Summers. He's been charged with first-degree attempted murder, kidnapping, sexual battery, and child neglect. The victim? His ex-wife and mother of his 5 children. 5 years earlier, Summers and 37-year-old Elisa Mathewson were going through a bitter divorce. The couple were living separately when one evening Summers, violating a protective order, arrived at Elisa's home at 2:30 in the morning. He was let in through a window by their 14-year-old daughter and went to the bedroom where Elisa was sleeping with their 2 youngest children. Summers then had the 14-year-old drive the children away in his vehicle. He then allegedly hogtied Elisa and sexually assaulted her. Later, Summers smothered her with a pillow until she became unconscious. When Elisa awoke, Summers placed her in the back seat of her SUV and drove away. Over the next 3 days, Summers allegedly held Elisa against her will, imprisoning her in locations across multiple counties and repeatedly strangling her. When she tried to escape in a pharmacy parking lot, Summers slashed her wrist. But a pharmacy employee saw the attempted escape and called police. When officers spotted Elisa's car the next day, they performed a felony vehicle stop, and Summers was taken into custody. The day after the kidnapping, the children were found unharmed at Summers' home. Summers was charged with multiple felonies and pled not guilty. Today at trial, Elisa takes the stand and recounts the terrifying details from the attack.
What happened after that?
Rope came from behind me over my head, and because of the position of my hands, it grabbed my hands, and he pulled the rope back and started strangling me.
When it comes time for the defense to cross-examine Elisa, Summers has a surprising request for Judge Christopher Sabella in regard to his attorney, Anthony Marchese.
I would like to resume self-representation and discharge Mr. Marchese as lead counsel.
And you believe that to be a wise decision?
Yes, Your Honor, I do.
The judge allows it, giving the defendant permission to question the victim, which he would do for roughly 4 hours.
Good morning, Ms. Matheson. Did I threaten you to have sex?
You broke into my home in the middle of the night when I was sleeping, attacked me and tied me up. I take that as, yes, you threatened me to have sex with you. Yes. You did hold me down. You did tie me up. You did attack me, and you did break into my home when I was sleeping. You raped me.
After a trial lasting 4 days, it took the jury just 5 hours to return with a verdict.
We, the jury, find as follows as to count 1. The defendant is guilty of attempted murder in the first degree. The defendant is guilty of kidnapping as charged. The defendant is guilty of sexual battery as charged.
Summers was found guilty on all charges. He was sentenced to life in prison with no chance of parole. Next, we head to Tampa, Florida for the case against 47-year-old Matthew Terry. Terry's been charged with first-degree murder in the stabbing death of his live-in girlfriend, 43-year-old Kay Baker. 6 months earlier, Terry and Kay, a third-grade math and science teacher, were out at a bar with another couple. A jealous Terry spotted Kay, along with her friend Kelly Andrews, briefly dancing with an unknown man. Kelly reportedly tried to calm Terry down, and the incident seemed to blow over. But when Terry and Kay got home later that night, he allegedly attacked her, stabbing her multiple times in the neck. Kay collapsed on the front lawn, and a neighbor called 911.
911, police, fire, medical.
I need emergency, please.
Do you know what happened?
My husband heard someone screaming, and then we came outside.
Do you know if this person was assaulted?
I don't know. We just came outside. They have a major wound to their neck, and they're struggling to breathe.
Is the blood spurting or pouring out?
You know, it's all over the ground.
When paramedics arrived, it was too late. Kay died on the scene from her injuries. Police, meanwhile, began a search of the home.
Sheriff's office, sheriff's office.
Inside, there was no sign of Terry. But just down the street, police spotted a trail of blood. Canine officers followed it to a group of bushes where they found Terry hiding in the brush, dressed only in his underwear. Terry was arrested and charged with Kay's murder, but he claimed he wasn't responsible and pled not guilty. The case went to trial, and the state sought the death penalty. One of the first witnesses to be called was Kelly Andrews, Kay's friend who was at the bar the night of the murder.
Did you specifically tell the defendant that Kay Baker was not dancing with the other guy?
Correct.
And how did the defendant react or respond to that?
I remember him saying something very strange along the lines of, I want to protect my queen and my kingdom. I was telling him he was being jealous and just to stop.
Perhaps the most compelling testimony of the trial came from someone who had nothing to do with the incident, Michelle Rogers, a former girlfriend of Terry's. 5 years earlier in Michigan, Michelle suffered a similar attack at the hands of the defendant. Terry was convicted of assault to do bodily harm, but served just 3 years in prison.
So what happens next?
He keeps punching me wherever he can find access to punch me, so whether it be the face, the chest, the back, wherever.
At any point, do you say something to him to try and diffuse this situation?
Yes, there was a point when I yelled at him. I said, you know, I love you. Why are you doing this? And he said, no, you don't. You, I'm going to kill you. And then the next thing you know, Mr. Terry comes around behind me and stabs me in the neck. This entire time, I'm screaming for someone to come help me. And when we both heard the sirens, that's when he got up off of me and ran back in the house.
After both sides came to rest, it took the jury a little over an hour to return with a verdict.
Was this jury able to reach a unanimous verdict in this case?
Yes, Your Honor.
We, the jury, find as follows. The defendant is guilty of first-degree murder as charged.
The jury voted against the death penalty and recommended a sentence of life in prison. Before imposing sentence, Judge Christopher Sabella had a final state for the defendant.
I listened to the testimony of Ms. Rogers. I don't know what happened in Michigan as far as the trial and the sentence, but based on what I heard, I believe that you should have been in prison in Michigan and that Miss Baker should still be alive. This is Florida. You're going to prison for the rest of your life.
Judge Sabella sentenced Terry to life in prison. He'll have no chance of parole. Next, we're in Stuart, Florida for a plea hearing. 25-year-old Austin Hariff has been charged with 2 counts of murder, attempted murder, resisting arrest, and burglary. 6 years earlier, after getting into an argument with his father, Hariff was walking home when he allegedly went into a psychotic rage and randomly attacked 53-year-old Michelle Mishkan and her husband, 59-year-old John Stevens III, outside their garage, killing them both. The couple's next-door neighbor, Jeffrey Fisher, called police and tried to stop the assault. He was also stabbed, but survived his injuries. Police arrived to find Hariff biting John's face. A police canine and multiple officers, one using a taser, eventually subdued Hariff and took him into custody. Hariff was arrested and charged, but claimed he couldn't remember the attack. He was held in jail without bond as the state prepared for trial, and the defense entered a plea of not guilty by reason of insanity. The prosecution's own psychologist agreed with the defense's expert that during the attacks, Hariff was suffering an acute psychotic episode and was clinically insane. Today, 6 years after the incident, Hariff's in court to plead not guilty by reason of insanity. The terms of the plea were agreed to by both the defense and the state, but the victim's family say they were never consulted. But before Judge Sherwood Bauer officially signs off on the plea agreement, several family members of the victims come forward to offer impact statements, including Cindy Mishkan, Michelle's sister, who tries to speak directly to the defendant.
You can't even look at me?
Ma'am, you would like
oh, wow, okay. I started writing my victim impact statement a long time ago, at a time when I was naive enough to think that there would actually be justice. At a minimum, a trial. Is it really so hard for you to understand that you are just a cold-blooded murderer, not a victim? You are disgusting.
Next is another of Michelle's sisters, Jody Bruce.
I'm frustrated with our criminal system, our court system. I'm frustrated with the state attorney's office. Can anyone imagine this? Can you guys imagine this? We've been waiting to talk to you for 6 years. Look at us when we speak. I didn't really know you could brutally murder 2 people, attempt to murder another, and not even have a trial. That was news to me. I didn't know that. I hate you. I hate you all. I hate what you did. I really think you deserve to die, Austin.
The last person to speak is Ivy Stevens, John's daughter from his first marriage.
I think about how slow his death was, how long it actually took for him to die, how torturous, painful, and horrific it must have been to lay there slowly dying with you on top of him, stabbing and tearing into him with your teeth like the disgusting animal that you are. I've had to watch you be portrayed as the victim someone that shouldn't be held accountable because you simply didn't know what you were doing. I call I hate you with every part of my being. You're a murderer, a monster, and a coward. I hope you suffer for the rest of your life, because that's what you deserve. I hope you burn in hell.
As the defendant sits quietly, Judge Bauer officially accepts the plea.
The state and the defense stipulated and agree that the defendant was not legally sane at the time of the offense. Based upon those facts and conclusions of the law, it's ordered that the defendant is not guilty of the offenses charged in the November 8, 2016 indictment by reason of insanity.
Then, Judge Bauer sentenced Harith to treatment in the custody of the Florida Department of Children and Family Services. He can only be released on a court order. We're in Fort Lauderdale, Florida for a hearing. 21-year-old Deontay Rezilis has been charged with first-degree murder. 2 years earlier, Rezilis allegedly broke into the gated community home of 59-year-old Jill Halliburton Sue. The wife and mother of two was alone at the time of the incident. Armed with a knife he found in the house, Rezilis allegedly tied Jill up, put her in the bathtub, and then stabbed her multiple times, stole money, and left her for dead. Jill's body was discovered by her 20-year-old son, Justin, who called 911.
What is your emergency? Mom! And are you with her right now?
Oh my God!
Is she awake?
No, she looks so cut up. Oh my God, my mom.
Initially, police told Justin he was a suspect, but when Rezilis' DNA was found at the crime scene, Rezilis was arrested and charged. He pled not guilty. At today's hearing, a judge will decide whether the death penalty will be on the table in the case. The courtroom is packed as bailiffs bring in Rezilis, as well as defendants from other cases on the day's docket. Earlier in the day, one of the other defendants secretly helped Rezilis unlock his shackles. And when he's placed in an off-camera holding area, Rezilis finishes removing them and takes off. This bailiff sees what's happening and races after the defendant, while others in the courtroom react. Rezilis, who it was later discovered had the help of accomplices in and outside the courthouse, removes his jail clothes and runs down 4 flights of stairs through a door that leads directly to the street. He then jumps into a getaway car and is sped away. 6 days later, police caught up with Rezilis, hiding in a hotel, and he surrendered without incident. 7 accomplices were later arrested and convicted for aiding Rezilis' escape, including the inmate who helped him unlock his shackles. 5 years later, Rezilis went on trial for first-degree murder. Out of respect for Jill's opposition to the death penalty, her family asked the state to seek a sentence of life in prison without parole. The state obliged. When the jury couldn't agree on a verdict, the judge declared a mistrial. A month later, the state tried Rezilis again, and this time the jury's decision was unanimous: guilty. Before Rezilis was sentenced, Jill's family delivered victim impact statements to the court.
You not just killed her. No, you didn't. You killed her in cold blood, like a psychopath. You stabbed her more than 25 times. Why? The real evil looks like that. That is a face of evil sitting there. An evil like you should not allow to be roam amongst us. And you leave the jail only in a casket.
Next was Jill's son, Justin.
The only person on the entire planet that knows the last words of my mother, that psychopath right there. and we'll never know what it was. She was probably screaming in pain. You're gonna be very lonely in a very tiny spot for the rest of your life. Just know that that's a fact.
When they were finished, the judge sentenced Rosilis to life in prison. He'll have no chance at parole. Next, we're inside the Alachua County Courthouse in Gainesville, Florida for a trial. 44-year-old Obadiah Dillard has been charged with a number of felonies, including robbery, attempted robbery, and robbery with a firearm. 4 years earlier, according to police, Dillard, whose record already included convictions for theft and drug possession, allegedly went on a week-long crime spree where, while claiming he had a gun, held up several stores and banks. Police say he'd then typically make his getaway on a bike, earning the nickname the Bicycle Bandit from the press. After his last robbery, police finally tracked Dillard to an apartment complex where his girlfriend lived, and he was arrested. Dillard pled not guilty, and bond was set at $750,000. Today, he appears in court for his trial, alongside his attorney, Erica Tria.
Thank you, ma'am. Please be seated.
The trial is beginning, but Dillard seems to have something else on his mind as he casually looks around the courtroom. Without warning, Dillard cold cocks his attorney. First with a hard left and then a right. Atria crumbles to the ground as deputies restrain the defendant, who immediately gives himself up.
Oh my gosh.
The prosecutor quickly steps over to try to help. Atria is expected to make a full recovery, but Dillard's vicious attack fractured his skull. He also suffered a concussion and broken tooth. For his attack on Atria, Dillard was charged with aggravated battery, a misdemeanor. But because of this incident and others like it, a new law was approved in Florida that reclassifies attacks against defense attorneys as felonies, making them more serious crimes. Dillard pled not guilty to the battery charge, but was convicted at trial and sentenced to 30 years in prison. His robbery cases are pending. Next, we're in Port St. Joe, Florida for a hearing. 26-year-old Henry Lee Davis has been charged with felony battery, resisting arrest, and in a separate case, battery in a detention facility. 6 months earlier, police say Davis assaulted his live-in girlfriend and then fled the home. The alleged victim called police, who quickly tracked Davis down and arrested him. Then, while in custody, he got into a fight with other inmates and was charged again. If found guilty of all charges, Davis could be facing a maximum sentence of 10 years in prison. Today, he appears before Judge Devin Collier to discuss next steps in the case, which includes an offer from the state to plead guilty and serve 5 years, 8 months in prison. Davis is represented by public defender Charles Williams, but it does not seem to be going very well.
Your Honor, Mr. Davis has rejected the state's offer at this point, which was the lowest permissible sentence offer.
Okay, so we'll see for trial. Yes, sir.
Speak. Show in court. Okay, he's not representing me properly. The man that said, "Oh, just take the charges, just take it, you did it, whatever, just be done with it." I don't feel like he wants to represent me. I don't feel like he's willing to represent me. I don't feel like he's capable of representing me.
You're asking that I discharge Mr. Williams?
Yes.
If I don't find that he is rendering ineffective assistance of counsel, you can still discharge him if you want, but the state would not be required to provide you any other counsel. You would simply have to represent yourself.
All right. And every time I tell him about something, oh, that doesn't matter, that doesn't matter, that doesn't matter. How you gonna tell me something don't matter? If it matters to me, it matters. You're supposed to be my lawyer. You ain't even representing me right. Come on, man.
Next, Davis wants to discuss his charges.
Specifically about the felony battery, you said it should not be a felony battery?
Okay, I've talked to my people. My people have been in contact with lawyers, and they have said we are staying under the same household, and we had sexual relations. It should not be a felony battery. And especially if I said that she hit me and she said I hit her, they don't take her to jail, but then they take me.
I explained to him that when the state charges great bodily harm, you know, it doesn't matter what kind of relationship you have with the victim, it's a felony.
Mr. Davis, whether you're living in the same house with someone or not, you can be charged with felony battery.
Are you sure?
Listen to me,
sure?
Mr.
I mean,
Davis.
you cannot charge me with a felony battery. Felony battery is like if I go off out there and go to hit somebody. That's a felony battery. I don't get why y'all having a felony battery when it's not supposed to be a felony battery. No way.
Are you finished?
That's what we're talking about.
Are you finished?
Come on.
Are you finished?
Come on.
If you're going to have a conversation with anyone, a part of it is listening, okay? I'll listen to you, listen to me.
I'm listening.
You can be charged with felony battery based on two things, Mr. Davis. Felony battery based on priors. The state has not charged you with felony battery based on priors. They charged you with felony battery based on great bodily harm or permanent disfigurement. And it doesn't matter if you two live together or not. Now, if you're saying that whatever harm the state is alleging doesn't rise to that level, that's a question for the jury, okay?
Hey, listen, just take him off my case. I don't want to talk about it anymore. Just take the man off my case. I'll do what I got to do, man. Just take him off my case. I don't want to talk about it anymore.
Whether you want to talk about it or not,
I just want him off my case.
I have a legal obligation to go through this hearing.
But y'all have your own law here?
Don't interrupt me. You do it again, you're going to be escorted out of the courtroom.
I'm going to go anyway.
Deputy Tower, you can get him out of here.
Davis is removed from the courtroom and taken back to jail. He's pled not guilty to all charges, and his cases are pending. As for his court-appointed lawyer, Davis waived his right to an attorney and is representing himself.